Hello, welcome back to HeirKare with Kathleen and Erik. We are attorneys with Fowler Baker Shade, located in Johnson City, Tennessee, and we provide estate planning and elder law services in the Johnson City region as well as in Suwanee, Georgia. As always, if you guys have any questions or topics you'd like to see us cover, please go ahead and drop those in the comments below. Today, we are talking about fiduciaries, and that's kind of a weird word that you may not hear a lot unless you're an attorney or actually a fiduciary professionally. So let's talk about what fiduciaries are. And a fiduciary is essentially an agent, someone who's acting on your behalf in a legal and ethical way for your benefit. This can be a financial type situation, healthcare type situation. That agent owes you, if you're appointing them, the duties of good faith, trust, confidence, and candor, meaning honesty. In most cases, these agents are people who cannot benefit from the transactions they are making on your behalf. There are some notable exceptions to that, but these are largely disinterested people who are there to help you. And there are laws and rules governing some of these more formal positions. And so some of these fiduciary positions, they take a variety of titles and roles. So Erik, can you tell us a little bit about what these fiduciary roles are?
Yeah, so we've done a lot of videos so far where we're covering what documents and things you might be using in your estate planning and elder law planning, all of those things. And we've kind of brushed over, just sort of said, hey, these are the people that are here. But we'll kind of just recap real quick what those are. It's, you're the trustee, whoever is the trustee under a trust, the executor, administrator, personal representative under a will, your agent under your financial or healthcare POA documents. They're going to be considered fiduciaries. And as we talked about in our last podcast, that conservators or guardians of finances or of the person. They are serving in a fiduciary capacity. Those are kind of the big ones. But also, your financial advisor, your accountant, your attorney, we all have fiduciary duties to our clients that we're required to follow and subject to. So obviously, it's a big job. It's important to make sure that you're picking the right people. So Kathleen, how do we pick who to serve in those roles?
Yeah, so the first thing you would want to do is you would want to think about the nature of the role you're picking. If you're picking a trustee who's going to be managing things in the event of your incapacity or when you pass away, there's a lot of administrative duties that go along with that. There's a lot of dotting I's and crossing T's, so you want to pick someone who has skills in that area. You want people who, if it's for a healthcare position, are not squeamish about medical things and they're comfortable talking to doctors and getting information, gathering information, sometimes consulting with your other loved ones. You want a person who can take those tasks on. You want somebody who is a reasonable person, right? You need someone who can think clearly and process potentially complex information. And of course, for healthcare, that can look a lot of different ways. For estate work, so trusts, financial powers of attorney, right? The more significant your estate is, the more skills and processing power people need to have to take on those roles. One thing that is absolutely fine in all of our jurisdictions, I'm not aware of a jurisdiction that still prevents people from outside of a state serving as an executor or personal representative or any fiduciary role. It's absolutely fine if the person you're picking, your agent, is in a different state. With technology and the ease of travel these days, very, very often, I would say almost as often as not, at least one of somebody's primary acting fiduciaries is from out of state. And that is absolutely fine. It's not a problem, at least in Maryland, DC, Virginia, Tennessee, and Georgia. Those are the states I can vouch for.
Yeah, well, and I know from when I've handled estates and things, often somebody who's out of state sometimes is easier for the attorney to deal with because they're kind of willing to let you do your job and stay out of the way and not ask questions. They kind of trust you as the person boots on the ground, and so sometimes they can actually make things move more quickly. The fact that they're not in state and they can hire somebody to do everything for them.
A competent, effective lawyer, yes, for sure. So Erik, that's kind of what you want to look for when you're picking a fiduciary. But are there any people we want to avoid or things that would be a red flag when we're naming someone?
Yeah, so people you'd want to avoid, most obvious one, obviously, if you don't like them, right? If they're not somebody you would want to spend time with, they're probably not going to be somebody who's going to do a good job or that your family would like spending time with to deal with stuff. It's kind of, like I said, it's kind of no-brainer, but it does need to be said.
Yes.
People who are bad with money, if they're just not a good financial manager, if you've watched one of your kids not be able to keep money in their bank account or not be able to make sure things are paid on time, they're probably not the best person to be placing in some kind of fiduciary role. Kathleen already mentioned this, on your healthcare stuff. If they are not good at making decisions under pressure, they're kind of squeamish about healthcare stuff and hearing about things from a doctor and getting into the details of what needs to be done, they're not going to be the best person to be making your healthcare decisions. And honestly, on the healthcare side, they probably need to be somebody who's willing to go to bat and fight with the doctor sometimes. They need to be an advocate,
Yes.
and not just go along with whatever the doctor says. They need to be willing to say, we need a second or a third opinion on this before we make a decision, and be willing to push on that. Somebody who has significant mental health or drug issues is not going to be a good, even just in the past. They may be recovered, but all of a sudden being placed in a fiduciary position where they have access to a lot of money may be a problem.
Money plus stress with that kind of history is a bad combination.
It is a very bad combination, and it's a very stressful job. And we can do what we can to make it smooth from the legal perspective, but end of the day, they still have to basically run somebody else's life for a period of time. And that takes time and adds on stress.
Yes.
And then overall, just you want to avoid people who are not good with administrative tasks. Sometimes this job can be pretty tedious. If somebody's, and frankly, especially if somebody ends up asking for an accounting, along the way,
Yes.
That's a very, very tedious administrative task that they can get themselves into a lot of trouble if they have not been doing a good job of keeping records and things along the way. And then, those are kind of flat out just avoid those types of things. But also, there's some people that we want to be careful when we're naming them. We know they're not flat out no's, but we need to maybe deal with some other, or ask a few follow-up questions on these people. If anybody's interested in the trust or the estate, if they're getting something, basically. There's some tax things and other questions that we need to check on to make sure that we're not undoing the strategy by naming this interested person, or if we are naming them, that we've adequately protected in the document, right? And then if people just don't get along, if your kids don't get along with each other, naming one of your kids as your executor or your trustee may be a problem. And so you need to make sure that you're considering those things as you go through. Or if they're just an obstructionist kind of person, they may be good at doing the job, but they also may make it difficult for everybody else along the way, right?
Well, Erik, you were talking about family relationships as well, and that made me think of another situation where I was advising a client, and it was a blended family situation, and they were considering giving one of the kids a greater share for valid reasons. That was fine. But then they were also considering, and their original plan was to make that person getting the extra money the personal representative of the estate. And there had already been some history there with the family. And I said, hey, I'm not here to tell you what is fair. And if you want to give them the extra money, that's completely fine. But let's think about the position you're putting that child in as personal representative, where there's already been some tension there. And now they're going to be in charge of giving their siblings or step siblings, half siblings, a smaller share of the estate, and they're taking a bigger one. And I just said, you might want to rethink that, because that seems like a situation where you're setting them up to have unnecessary relational challenges. So there's things like that where maybe the people have complete capacity and they would do a great job, but if it's not going to work with the dynamics of your family or your beneficiaries, that's just another factor to consider.
Yeah, and I know something I run into quite often, and I'm interested to get your take on this, on how you address this with clients, is sometimes they don't want to pick one of their kids. Right? And they feel bad to put somebody over the other ones.
Yeah.
How do you address that when people are like, but how do I decide between my 4 children which one gets to be in charge?
Yes. So sometimes, and we'll talk about this a little more, you can apply co-agents, 2 people to act, or even more. And sometimes that works and that's appropriate. Sometimes we just talk about the skill sets and who's got the bandwidth and the time to do the job, and you select based on that. Sometimes it is appropriate to name someone who's not one of your kids. You know, if you've got a niece or nephew who's a CPA, or your sibling is a CPA, or a lawyer, or an accountant, and it just makes sense that this would be an easy thing for them to step in and do because it's already in line with what they're doing, then maybe that's a better person to name. And then you can name people as backups. Obviously, you can still name your kids. And when we are doing estate planning, there are multiple roles involved. And so sometimes, let's say we've got 4 kids, and that parent's definition of fair is everybody gets a role, right? Maybe you've got 1 kid as the personal representative, you as primary. Again, if there's a spouse in the situation, maybe they're backup, right? But you're choosing 1 kid for the financial power of attorney, 1 kid for healthcare. Maybe you pick a different kid for personal representative of your estate. If you're doing that kind of planning, if you're doing a trust, maybe you pick a different kid for the trust. And so sometimes that makes people feel better because it's more fair because everybody has a role and a job, and that makes it okay. Sometimes people just say, well, they're the oldest, they get all the work. And
Yeah.
as
Sorry,
you're talking to
you
2
were born
oldest people
first.
right now, you were born first, therefore enjoy your responsibilities. Which, that's also very common. And so that's kind of how I've addressed that and seen that play out.
Yeah, I got hit with the double whammy on my family. I'm the firstborn and I'm the attorney in the family, so there was no doubt who was getting
Same.
named as the
Same.
trustee of the trust.
Well, and I joke, so I'm from a blended family. I am primary or backup 1, 2, 3, 4, maybe 5 people's estate plans. And I have told all the individuals, if you guys are ever all on a plane together, I'm on that plane with you, because I am not going to, because everybody's plans would be interwoven, right?
Yeah, I'm not doing 5 people's
I'm not figuring it
estates
out.
all at once.
I'm not figuring it out. I'm going to just go down on the plane with you. So that's our family joke about. Sometimes you've got an obvious person like the lawyer who you're going to pick to be your fiduciary for all the things, but sometimes not. And so I think one of the other things you can do that I mentioned before is you can appoint co-agents in most situations. An exception to that is certain jurisdictions, Virginia being one of them, you are not allowed to appoint, or they will not accept co-agents for healthcare decisions. You have to pick a primary. And this does make sense because oftentimes you're in situations where decisions need to be made quickly and there's very potentially drastic consequences of those decisions, and we are in life and death situations sometimes when your agents under a healthcare power of attorney are acting. And so in Virginia, they're like, no, you get 1. You can name a backup, of course. You can name as many backups as you want, but you can't grant that power to 2 individuals. In my other jurisdictions, you can. I'm going to circle back and let Erik give you his philosophy on healthcare powers of attorney, which I agree with. But you can, for your finances, you can appoint people to act jointly or independently. The banks have a strong preference towards acting independently because they don't want to worry about getting everybody's signature and having that extra administrative task and responsibility on their end. But it absolutely can be done. In trusts, you can have even committees, essentially. So you can name as many trustees basically as you want, and often when you have multiple trustees, the decisions have to be made by majority. But if you have a much larger group, you could set that threshold yourself within your own trust. And we do generally, in our documents at least, when we are drafting, we allow individuals to even if they are the only trustee, to name a co-trustee to act with them. And this can be helpful in different situations. Number one, maybe it's just a lot of work and they need some help and they want to offload some of that and they want to pay a professional corporate fiduciary to do that. Sometimes you need to be able to have a co-trustee appointed for certain financial transactions because a trustee can be a qualified intermediary. Also, there's something called a real estate investment trust, where if you are trying to do this with your own trust and invest in that, you have to appoint one of their individuals as a trustee. So there's some technical situations where that power is required in order to take certain investment strategies. And so, Erik, why don't you tell us a little bit about your thoughts on healthcare power of attorneys? And I will just second ahead of time what you're going to talk to us about.
Yeah, so in particular with healthcare POAs, I strongly advise my clients against naming anybody as a co-agent with somebody else. Namely because I've got a little bit of PTSD from a conservatorship matter that Kathleen and I worked on together, where basically brother and sister were named as co-agents on the healthcare POA, and there was no tiebreaker language in there at all. And they disagreed on what to do with mom, and it was a pretty significant decision. And the hospital ended up having to plead the whole thing into a conservatorship to have a court basically decide who they should listen to. And in the meantime of everything going, mom passed away. Yeah. And it ended up, no one was able to make a decision that needed to be made along the way, when we could have, if we had just clearly said this is who ultimately gets the final say, would have cleared everything up, and we would have been able to get mom the care she needed along the way. Because I think that's a situation where it's just a no-win for everybody. Yeah. And so I always just strongly advise against it. Ultimately, if clients decide they want to go with it, that's their prerogative. But I always make sure that they are fully aware of the risks before they do it. And we almost always try to, even when we are naming co-agents, we try to come up with some system of deciding if they do disagree, how are we going to break that tie?
Yeah, for sure. So, Erik, before I talk about backup option, if you don't have any friends or family to help you out, and those being corporate fiduciaries, why don't you talk to us a little bit also about consequences of bad picks? You touched a little bit on this with naming two people as healthcare, but there can be some other significant consequences of choosing poorly.
Yeah, so particularly on financial roles, so a trustee of your trust, your financial power of attorney, the executor of your estate, you're trusting somebody to handle a lot of money often, and they are in a role where they could essentially take everything, cut bait, and run, and take all that money, right? We sort of tongue-in-cheek when we're doing our signings, we'll tell people, now remember, you're naming people under your financial POA who can rob you blind. So you need to trust these people. It's a very real possibility. Typically I think people do a good job of, if they're counseled well, they pick the right people, and that doesn't happen. And that's not to say there's not any recourse for your family if that does happen. It's just at that point they're in the position of having to file a lawsuit, which at a minimum costs a lot more money, and then you have to hope that you can get the money back from them before they've spent it all or moved it offshore somewhere that you can't get to it. Yep. And so it's a relatively big risk if you pick the wrong person there. The other one I've seen a lot, frankly it's probably where most estate litigation comes from, is an executor or a trustee who just sits on their hands and doesn't do anything. Yeah. They're either afraid of doing something wrong, or they just want to stick their head in the sand and act like nothing's changed. Whatever the reason might be, they sit around and don't do anything. I've handled a trust lawsuit where two sisters were supposed to, basically there were three houses, two of them, they were each supposed to get one, and then the mom's house was supposed to be sold. And the one sister just sat on her hands for 3 years and didn't do anything with any of it. Spent a whole bunch of money fixing leaks in the houses and things when problems confronted her, and ended up dwindling down the trust fund that was available to actually be distributed. And all of that could have been avoided if she had been a little more on top of things, or at least it could have been passed out to them separately to deal with their own things, as opposed to them having to fight over it later on. It ended up costing them a lot of money and legal fees to fight over it. And it ended up being just not good for anybody. So those are kind of the big ones that I've seen. And Kathleen, I'll turn it over to you to talk about kind of what happens when we have elder abuse situations, because I know that's a lot more of where you've practiced and dealt with.
So it is not uncommon for loved ones to financially abuse their older relatives. Now, I'm not saying it's everybody, of course. There's plenty of people out there doing the right job, but it is particularly reprehensible, I feel like, when you're doing this to your own family. And I had a situation once where this grandmother's grandson moved in with her, and she gave him power of attorney, and she said, I want you to be able to live here. I'm going to go ahead and turn over the house to you so that if I ever need long-term care, because there is an idea out there, well, if I go ahead and give my house away now, it's protected. Well, it's protected to the person you're giving it to. And this grandson, I think, probably had some substance abuse issues as well that maybe she didn't originally know about. He had moved into the house, moved his girlfriend into the house, and literally once he was the owner of the house, within a couple months after that, kicked his grandmother out and said, this is my house and you need to go find somewhere else to live. And she was elderly, had to go find another elderly relative to live with, because unfortunately there wasn't a strong family structure and people who had the ability to take her in. And it was just a really sad, heartbreaking situation. And, she had capacity when she did these things. She willingly gave her house up. And so, who we trust in life, just because they're family doesn't mean they're trustworthy. And sometimes people feel like they have to pick those individuals because that's who they've got. And I just want to let you know that there are corporate fiduciaries, there are professional fiduciaries who can serve as financial powers of attorney, as the personal representative of your estate. They can serve as trustee. It's hard to find and not available in all geographic locations, but in some cases there are companies set up who will also serve as your healthcare power of attorney. And so if you feel like you don't have anyone, first of all, it doesn't have to be a family member. You can choose a friend, the kid of a friend, right? Your best friend's kid that, is like your niece or nephew. You can pick them. It doesn't have to be family. And if you really don't think you've got any reliable, trustworthy options, they cost money, they cost your estate, right? But you can name a corporate fiduciary. And, we have a list of people who we work with and trust and refer our clients to. And so if you are doing your estate planning and you are in that situation, which I do think is becoming more common because family sizes have shrunk, and there's a lot more people who have chosen to either not have kids or not be married, not have those partnerships where you develop those wider circles. And in some situations, we have people who've literally outlived everybody else. But in those situations, there is still help available, and your attorney can help you find those resources so that you don't end up in a situation where, you're the victim of financial abuse. And those corporate fiduciaries are subject to very strict state and federal rules, just like your financial advisors are and CPAs and like us. We have very similar rules that govern us and boards we answer to. So that's always a backup option if you feel like you don't have other good options. So before we sign off, Erik, any last thoughts, questions, stories? Insights?
Yeah, I do just want to jump in and say on the corporate fiduciary side, they can often also be a solution for when your family doesn't get along.
Yes.
Sometimes you can just say, you know what, we're going to hand this over to an objective third party, and they're going to handle everything according to the trust, and everybody's just going to have to deal with the fact that it costs money. I also do often like to point out to clients, yes, it costs money, but it's not hard. They're usually charging maybe 1.5% along the way. It is not hard to invest that money in a way that is going to outpace that cost. So the cost to me, maybe if you have a relatively small estate, maybe under $500,000 total of everything, maybe it might not make sense, but past that, really, if you have concerns or you don't have somebody, the cost should not be a reason why you don't do it. You should definitely shop it around and find the best fit for you. But, end of the day, making sure that things are handled properly and efficiently and well for your family is more important than paying a percentage of your estate to somebody to do that for you. So that's just one big caution I do like to throw out there, because I hear that all the time. Well, I don't want to pay somebody to do it. Well, there are times when it's appropriate and where it's necessary, and so you shouldn't let that turn you away all on its own.
And just to add one more thing on the corporate fiduciaries, because I think some people, when I say corporate fiduciaries, they might think of the trust department at Schwab or Wells Fargo or JP Morgan, and they think, well, you have to have a minimum to be with their trust, etc. There are local and more regional based trust companies that I would suggest provide a little more personalized service. They're more reachable. They are hands-on. There's a lot of rural land, family farms and stuff, and I know one trust company, and they're like, hey, we can manage the family farm. They'll go to the property. They will meet up with you and talk about what your goals are for people, so that when they are in the position of managing the money, they've got those notes, they've met with you. It's not just words on a paper to them. It's a relationship that they understand, and they can then steward your resources that you leave for your loved ones very, very closely to how you would have done it yourself. So, it's not just the big banks. There's smaller ones.
No, the bigger banks are trying to get out of it a lot of the time now.
Yeah.
They're closing down those divisions.
Yeah, like Northwestern Mutual, huge financial investment, life insurance. They have a lot of products. They don't have their own internal trust company. They have a list of people that they work with, and they basically have a referral list, essentially. It's a really solid option, and I've been glad to see when my clients have those meetings, have the sit downs and talk about it and move that direction, because I just think it takes a lot of work off people when they're grieving. It gives that client the confidence that, hey, there's somebody really top of their game who's going to be taking care of this for me. So, got anything else for us, Erik? Did we miss any important things?
I think that's a big bit of it.
All right. Well, thank you guys for joining us today. Remember, this is just information, not legal advice. And again, you've got any topics or things you'd like to see us cover, go ahead and let us know. Have a good day.